deputy zoning, UDIN, deputy zoning inspectors. I will call the roll. Ms. Yu?
Here.
Mr. Wilcoxon?
Here.
Mr. Campanella?
Present.
Ms. Guest? Mr. Holleran?
Yep.
And Mr. Phillips is absent. And I will read this into the record. Actually, I won't read it into the record about the policy of public comment. We will not have any public hearings this evening, and therefore there will be no public comment. While the public is invited to join and watch, we will not accept any comments from them this evening. The first item of note is review and approval of the meeting minutes from March 18th, 2025. I'll let you take a moment to look those over, and then I will entertain a motion for approval, which I didn't do the homework today, so. Okay, good. Okay, I'm just going to make a motion to approve the minutes for March 18th, 2025. Do I hear a second?
Second.
Second by Ms. Yu. All those in favor of approval of the minutes from March 18th, 2025? Oh, discussion? Anyone? Questions? Signify by stating aye.
Aye.
Any opposed? Any abstentions? Okay. The meeting minutes are approved. So, okay. I guess at this time, we will have our guest. Can I hold you for a minute? Okay. I think it might be good if we went around the table and everybody introduced themselves to the group, since we have some new people. So why don't we start? You're not new, Mark, but if you want to just introduce yourself and.
Sure. My name's Mark Campanella. This is my second meeting as a member of the board. Prior to that, I was an alternate. I began middle of the year, last year, 2024. Been in Genoa Township for 20 years, and my former occupation prior to retirement was a IT executive with IBM.
Okay. Michael?
Excellent. Well, this is my first meeting. I'm Michael Holleran. Actually, I am the alternate, but it looks like I got called up for the first time in here, so I sent a picture of this to my kids, and they liked it. I currently work in IT, mostly for Chase, but I've been in the township. I've been in Westerville for at least 10 years, but in specific Genoa Township almost 3 years, and just glad to be here.
Welcome.
Okay. I'm Mark Harmon. I have been on the board, oh God, I shouldn't tell you. I've been on the board 13 years. I did start as an alternate. I was an alternate for a year. And then I was moved up into a 5-year appointment, and I'm on my third appointment. I've been chairman for 4 or 5 years. I am a real estate appraiser, certified residential real estate appraiser by trade. And I have lived in the township since Labor Day of 1999. So, and I will add, I would be, prior to this, I was also on the Parks Board for a number of years along with Teresa, so.
Yep, I'm Teresa Yu. I don't talk near as much. I've been on the board a while, a little bit longer than him, and I've lived here 26 years, so. Yep.
I'll talk less. I'm Travis Wilcoxon. This is my first meeting. Been in the township for not quite a year yet. It'll be a year, May 5th. And I currently work for the City of Columbus Code Enforcement.
Okay, Gail.
I'm Gail Guest. This is my first year. I'm an alternate. Retired in the accounting finance field. I was an executive chase, and then I was in a consulting firm.
Okay,
And I've been in Genoa Township 20 years.
all right. Okay, now let's turn it over to our consultant that's going to be leading our overview of BZA. And if you'd introduce yourself and then go ahead and take it away.
I often think of myself as a fairly loud speaker, but I will honor the microphone request. My name's Jennifer Huber. I'm a lawyer with the law firm of Brocious, Johnson & Griggs. We serve as special counsel to the township, so to the Board of Trustees, to the Zoning Commission, to staff, to you all, with any number of things. But one of the subjects that is near and dear to my heart, as nerdy as that sounds, is zoning. You could have never told me ahead of my current job that I was going to be a real property or a zoning attorney, but here we are. This year marks 12 years as an attorney and 11 doing township work. So happy to be, like many of you have said, happy to be here, happy to be doing this. Training is one of my favorite things as well. I hope this is more like a conversation than me talking at you. I am not going to read this verbatim because that drives me crazy when people do that. So ask questions. If I skip something that was like you marked it or you flagged it for yourself, don't think that it's not important. I want to make sure we're making a good use of your time. So drag me back, take me to whatever piece you wanted to talk about. If you have real life and or hypothetical scenarios you want to run past me, as long as they're not like a future case that you know about. Obviously, we don't want to pre-discuss a case that's coming to you. But if you want to sort of run hypotheticals of things that have already happened or questions you had that maybe went by the wayside at the time because you had other things going, this is the time. Let's have that conversation. I know I haven't seen it all because every time I think that, I am wrong. But I do feel like with the number of boards that I get the pleasure of working with, I have seen a lot. I have run through a number of the nitty-gritty questions myself. So happy for that to be a moment for us all to share from and get some information. So ask your question just straight out, raise your hand, flag me down, whatever you want. This, I think, should be a conversation. So I want this to become comfortable for everyone. Also, in case, just as a roadmap for the materials that you have, the first, 13 pages of legalese are like sort of an outline of your jurisdiction, your responsibilities, how you might run a meeting, things to keep in mind, creating a good record, all like the nuts and bolts of BZA operations. Then there are a handful of what I'll just call sort of like reference resources in the back. Take them, I mean, especially, I guess it would end up being page like 14. It's a sample format, completely a sample. There is not a legal reason. You have an incredible resource in staff. We present this training to townships that have 0 staff, townships that have lots of staff, and everyone in between. So I give the resources in case it's useful. If it's not useful, because this is an incredible resource, have at it. As well, I also sent you some pieces of Ohio Revised Code straight out of the law in case you need having any trouble sleeping at night. Just pull one of those out and read it right up. But these are the ethics. I included the ethics laws. Again, very dense. But they are important, and so I wanted you to have those as a resource, and you don't have to go hunt them down somewhere, so they're in here as well. And then last but not least, and we can touch more on this at any point, the Ohio Ethics Commission, you are public officials, appointed, elected, or otherwise. You are under the arm of the Ethics Commission. You're responsible for those. We'll touch more on the laws. But they are a resource. It's a state agency that provides assistance to all public officials in the state of Ohio. So you could call them up with a question tomorrow during business hours and see if they could help you. If you had an ethics, a conflict, personal interest in something or other, right, that you were worried jeopardized your ability to serve in an unbiased way on this board, you could call them. You're also welcome to call me at any point. I am sure the prosecutor's office would help as well. But in case you ever want that, again, just throwing information your way. Their number is not only at the top of this, it's on the website, it's in my materials. So the beautiful thing about the Ethics Commission, and not to skip to the end before we've even gotten started, but if you call them and if you give them enough time to render an opinion on your matter, that's not, don't call them the day before, go, no, then if they have time to issue what's called a formal opinion, they will basically stand by their formal opinion. So say they tell you, no, sir, ma'am, that's not a conflict, you can serve. If, in a formal way, if an applicant later said, oh, they shouldn't have been allowed to serve, and you relied on the advice of the Ethics Commission, they'll basically defend their decision in that instance. So keep it in mind. I don't think you need a formal opinion each and every time. They're a resource all of the time, but for what that's worth, again, I'm happy to help too. And I know, like I said, prosecutor's office staff can help. Everyone's a resource in that situation. And we can talk more about what to look for, what to be aware of, but I wanted to flag that. They have a number of these kinds of like handouts, worksheets, things to think about on their website. Lots of good stuff to read again. If you're into that kind of stuff or if you have that question. So without further ado, we will start from the top. And I'm not going to spend a lot of time on the first couple pages because I want to make sure we make it to the meat. But I do want to hit a couple high points. First of all, Genoa Township is a statutory township. So the township has the powers given to it under Ohio law. So if there's basically when the township, any of you folks, staff, trustees, if anyone calls me and says, Jen, can we do this? I go to the law, or I go to the law and I find a way, I find a statute that either says you can or you can't. And if it says you can, then you can. If it says you can't, then you can't. And if there's no statute that gives that authority, you're out of luck. That's what it means to be a statutory township. The only exception to that, if anyone's ever heard of a limited home rule township, if you've ever lived in another township that had sort of like a heightened level of authority, although it is not, if you think of true home rule, cities are the only ones with true home rule. And this is your trivia, at least one of your trivia give yous for the evening. Cities get their authority from the Ohio Constitution. That's where they spring forth from that. Townships come from statute. So in the order of authority, Ohio Constitution is above Ohio laws. And so cities' home rule powers are stronger. They can do this is generally speaking, but more or less whatever they want, unless there's a state law that conflicts or federal law that conflicts, then cities can write what they want. So don't think home rule like cities. Even a limited home rule township, hence the limited, can do a number of additional things, but still not the level of a city. So when cities sue either the state or federal government because they've overstepped their bounds on a given law, that's what they're resting on. They're saying, I'm a city, I can do what I want, I have done what I want, and your legislative action has abridged my home rule authority. Again, trivia for a rainy day if that ever comes up. But where we are is we need to find a statutory ability to do what a township wants to do. What I do because of that, what I want you to take away in your zoning mindset is that our law, our code, which is a law, the zoning resolution is township legislation. It's the biggest, most comprehensive piece of legislation that any township really has. We need to make sure that this law fits all the constitutional parameters, right? It can't run afoul of any state laws that say what you can and can't do. It can't run afoul of any federal laws that may conflict, and it can't overstep any case law, so courts that have looked at either the law or codes, and even if it's not your code, and interpret it one way or the other. Yes, they could do that. No, they couldn't. And we're going to talk about a few of those limitations. So constitutional limitations, again, these are the big picture. These are the big picture items. So if someone is suing a township, suing a BC, however it filters out, they're usually saying, you overstepped. You went too far. You weren't allowed to do that. Your law was unclear, vague, or one of my favorite ones in a zoning context, affected a taking, an unconstitutional taking of my property's rights, value, use, ability, et cetera, by your, it's called a regulatory, so by regulation, you've stopped me from being able to do something. As an aside, folks who come to you and say, that's a take, if anyone, I don't know if you've ever had folks get, it's not enough to just, a taking is not occurring if by regulation, one of the uses someone could have done is now taken away. That by itself is not enough. It's not a single thing. It's not enough for Jen to come in here and say, I wanted an ice cream shop, and you prohibited ice cream shops, so now I can't do an ice cream shop. That's a taking. What Jen should properly say, if this was true, is you eliminated every use that my property could meaningfully be put to, and now I can't make any beneficial use of my property. That's a taking. It's not a single thing. It's not one thing that she wanted to do something. And I'm saying it that way because that's usually what I hear. Folks are understandably upset, and they say, immediately right off their defense is, that's a taking. If that is ever the case, and why I'm putting this on your radar is, don't be paralyzed if someone comes in and says that, right? Carry on with your process. Whether it's a taking or not is not something that this BZA is going to need to figure out in the moment at a hearing. That's going to be something that Paul and I, or staff and I, or the prosecutor's office, someone's going to get involved and evaluate whether there's been a taking or not, and if so, what the township wants to do about it. So if you know just enough to hear that word and just, carry on your way, be consistent in your process. Don't let that be the thing that just stifles the whole process. And because I do have townships that know enough that gets thrown or wielded as sort of like a sword against them sometimes, and they want to kind of freeze. And I'm like, we don't have to freeze. That's not going to get resolved tonight, right? If somebody's saying that's happening, that's not going to be something that any of you have to, in the moment, make that determination. It's going to be a highly fact-specific, highly legal determination based on that particular situation. So I wanted to put that on your radar. Those were the constitutional items I wanted to talk about. Additionally, statutory limitations. If you've ever looked at, for fun, the agriculture statute in the township Title V, that is because, and my uncles are farmers, my grandparents were farmers. That law is both incredibly complicated, unnecessarily so in my mind, but also incredibly ag protective, wildly ag protective. I mean, again, I understand it. Ohio is an agricultural state and proud to be so, right? That law was well lobbied. It is a very powerful, very pro-ag law, and the bane of my existence sometimes because of the way it sort of carves itself through. That's an example of a statutory limitation. So that law says that, and one small piece of it is, if someone owns more than 5 acres, the township cannot regulate agriculture on that property. So you will find no section in the zoning code that says that we can, right? So that's a statutory limitation on how far we can take this. And there are a number of others. Cell towers. Let's see, what else do I have on here? Ag, cell towers, lawful non-conforming use. Okay, let's talk about that one a little bit, because again, this is another place where, taking a zoom out for a minute, many of these are not going to come in front of you, right? These limitations, conversations or considerations, many of these are legislative. They're going to be considerations for staff, for the zoning commission, because they're part of your legislative process, and the board of trustees, who are the ultimate legislators when it comes to your zoning resolution. But again, going back to that takings conversation we were having, I want you to at least have heard it and you think back and you go, Jen we talked about that one time, and she said not to worry. She said not to be, remember it that way. But in the process of things, it's gonna be the legislators in the township, the bodies that do that, who are gonna have to figure out, again, how far can we take this zoning code? But I will tell you, so lawful non-conforming uses, that's the legal term for grandfathered uses or structures, which means that a use or a structure that existed lawfully on the day before the law changed, right? So I always use the example of, because I go through, I'm from the Logan County area, and so between my parents' house in what's now Shelby County, and which I was just there this weekend, and my house in Franklin County, I see a number of these just little villages, right? And I always think of the little villages where the houses are, and I know that's not just villages, but where the houses are like 5 feet off the road, right? That's because 100 years ago, we either didn't have zoning or that was compliant. We put houses 5 feet off the road. The road wasn't that wide and no one had just giant cars coming right. I mean, that just was a different time. Now, traditionally, I don't know your code inside and out, but I suspect that you have more than a 5-foot front setback. And so now I use that as sort of a trigger now that I'm a zoning attorney, right? I go through places, I'm like, oh, that's probably non-conforming, right? That probably existed, again, perfectly lawfully at the time it was constructed. It just so happens that the law has changed. And the rights reserved to someone in that position, whether it's a structure that's too close to the road, or they're running a use out of a property that's not permitted anymore, but it was at the time, they're entitled, they're basically vested with the rights to continue that house being 5 feet off the road or that use being operated on a district that doesn't allow that anymore. If they were I keep hinging on lawfully. It does not, lawful nonconformities does not bless a use that was a violation on the day before the code changed, right? If you were a violation the day before the code changed, you're still a violation the very next day. But I have those conversations from time to time. I love those ones. But if they were, again, vested with the right, they were operating at the time. It can't be conceptual. It can't be, well, Jen thought she might open a nail salon in 10 years' time, and so she should be allowed to open it now, even though it's prohibited. Not true. No, if she didn't pull down that use to herself and start making use of it, if the house wasn't already built like that, using my examples, she has not vested herself with that right. And therefore, she doesn't have that right to come in to staff or to whomever and say, well, you can't take that away from me now. You can't call that a violation now. I was lawful at the time. You changed the law, and so I'm going to be allowed to continue that, again, structure or use, because we've decided as a society, again, this is out of state law, but also lots of court cases, that if I have vested myself with a lawful use, I'm going to be allowed to continue it until I abandon it. You have like a two-year abandonment. So it's typically, and I don't have that section in front of me, put you on the spot, pop quiz. Unless I abandon it for 2 years, in which case, then I have to bring it into compliance. That's obviously not true with the house, right? We don't have a public information campaign where we're telling whole villages that they need to push their houses back 20 feet. No one's doing that. But if I opened a nail salon, law changes and prohibits it, and then I give it up for 2 years, and then I say, well, I'm going to open it up again. No, I will have legally abandoned the use if I have stopped that operation. So again, I'm telling you probably just enough to be dangerous, but I wanted to float that. Again, not every, it's grandfathered or it's a lawful nonconformity is true, right? Someone doesn't just get to say that and wave a wand and it becomes that way. It has to meet some requirements. It has to be established that it was lawful at the time. And the burden of proving that it was lawful at the time actually falls on the owner, the person saying that it was. So I've had people, I had a Franklin County court case where someone was like, I swear that property's been used so it was zoned in one of their business districts. This is in Prairie Township on the west side of downtown, like Broad Street and 270 Broad Street on the west side. Swear it's been used, it's been used for commercial property. It's kind of like an office. I wouldn't say it's full industrial, but it's kind of like, I don't know, like car repair, like lawnmower repair kinds of stuff. So not full industrial, but then he was sure that it had 2 like second floor apartments forever and ever. We take him to court, we say, no, we have no record of that. He applies for conditional use, because it was a conditional use, it gets denied, it just wasn't the right fit for that area. Well, it didn't make sense for that part of the township. Gets denied, and as predicted, he removes none of it. Removes none of it, stops none of it, just says, So it goes to court, and he had his attorney working on trying to get like AEP records, trying to prove that there was and that's fine. Make your case however but ultimately he wasn't able to connect the dots. So he eventually voluntarily stopped the use of the property for those dwelling units. So,
Could I ask a question?
of course.
Great. First, thanks. You obviously have a tremendous amount of expertise and
Thank you.
depth in all this. There are 4 people here who have very, very low levels of experience in this
Sure.
and in government. We have new folks, we have myself, and we have a new gentleman at the end who has obviously some expertise given his role. Based on the size of the document that you gave us here today, what do you think are the top 3 to 5 things that new people coming into this role need to know and to keep at the front of our minds every time we come in the door for one of these sessions?
So after I hit the constitutional and the statutory limitations, I was going to move to the next page. It's page 4. And we're going to talk about the BZA's jurisdiction and some of your rights and responsibilities. And then I was going to talk about the variance standards, which start on page 6 and 7. And I don't know how many I'm up to now. I was going to do conducting the hearing on page 9. And then conflicts of interests on page 12.
If we could just have a quick summary of what the most important things are about those topics, that would be great. That would be awesome.
So right now, do you want me to do that, or as we go, is it okay if?
No, I just think it would be great for us to have a sense of what the top things are you want us to know about, and a little bit of, within time limits, of course, what those things are that you want us to keep in the top of our head as we go through this job as neophytes.
I want to make sure this is valuable to you. Am I losing you because of level of detail? You can tell me. I'm not going to hurt my feelings.
All I'm suggesting is that the wealth of information that you presented in your first 10 minutes was probably more than many of us could process.
Okay.
If you went into that level of detail.
Okay.
With everything here. And
Understood.
I'm just speaking for myself.
I appreciate you letting me know that.
So I think it's more or less what are the rules of thumb for us to understand, with you being an expert, for us to do this job effectively and efficiently as, employees of the state, or the township.
Okay, understood. So with that in mind, let's turn to page 4. So I'm going to hit the high points on this page. The board is quasi-judicial. So in the township, there you have sort of an executive/legislative branch, which is the township trustees. They are like the village council, city council, that's your township trustees. They are both executive and legislative, meaning they create the law, they are the policy, and all of the above. You also have a zoning commission. They are the other half of the legislative branch of the township. They work in a recommending body with the trustees under state law, under your code. And then we have all of you. You are the township judges, for lack of a better term. You like the people who apply the law. So you don't sit in the same capacity, the same way as the legislators do, the executives do. You're also the only body like you, right? You're not like the zoning commission where your decisions, you make recommendations up to another body which has the final say. You have the final say, which me is a blessing and a curse. It means that the process needs to happen with you. The ins and outs, the making a good record, that's you and only you. There's no one else to sort of clean it up later, not that you'd suggest that. You can be appealed directly to court. And that's not to scare, that doesn't worry me, people. Again, my job is not to make sure you don't get sued, because no one can promise that. My job is, and staff's job is, to see that you are prepared for and that you have made the best reasoned decision that you can on a given case that comes in front of you. And I have some tips, tricks, tools, case law.
And I think that's the most important. You talk about getting
Sure.
sued. I've been here, I guess, longer than everybody in the room. I can only think of one instance where we've been actually sued based on a decision over here on Sunbury Road,
Mm-hmm.
which Sunbury is kind of a unique entity anyway.
That's a pretty good
And
track
it's
record.
been a long time.
That's great. I'm knocking on wood. You see me?
Yeah, well, yeah, so we're,
No.
But along with that, though, we have had, and maybe spend 30 seconds on this, is that because we are quasi-judicial,
Mhm.
is we have had a case within the last, 12 months, where a resident who didn't actually have standing did appeal a decision on actually twice, on a zoning, or I guess the primary one was on issuance of a zoning permit by the office. It came to us, and it was like a court hearing, and it came to us, and we had to make a decision. And we actually never made a decision on the case because we determined very early on, because the respondent had a very, very good attorney, it proved that the plaintiff had no standing whatsoever. And so, like I said, we never got to the merits of the case because there was no standing. So you might want to talk about that a little bit.
Sure. You've had 2 appeals in the last recent?
That was an appeal.
we did
That
one-
was, issuance of a zoning permit that a nearby resident was unhappy about.
Yeah, that's called administrative appeal. We had one that they denied to hear because it was after the 20 days
Yeah,
that we allow
okay.
for administrative appeals.
Mhm.
And then we had a second one which got thrown out for lack of standing, but we did have one, yeah.
Interesting. Well, some townships go, maybe we had up to that point, decades and no.
That was
what
our
I'll call
first
an
one. I've been with the
appeal.
township about 8 years. so.
Gotcha. Okay, so when it comes to standing, right? Generally speaking, when applicants are in front of you, let's put the appeals piece aside.
Okay.
When it comes to your bread and butter, right? Variances, which are someone asking for a change from this code, something different. They want to vary from the requirement, fine. Or a conditional use, which means any use that's been designated in your code as, rather than straight up permitted or everything else prohibited, it's a conditional use, which means practically, policy-wise, it's a use that the writers of that section, so the trustees, right, decided was appropriate sometimes in that district, but that they wanted this board to take a look at it. A common one is self-service storage. Like, are there times and place, and maybe that's not common here, but I have run into that as a conditional use many times. Do we all have too much stuff in our houses? Yes. Do we all need it someplace? Do some of us need somewhere else to put it? Yes. Do we want a self-service storage, and just fill in self-service storage with whatever makes sense to you, but on every corner in the township? Probably not, right? Probably not. So lots of townships, lots, not everyone, certainly not required, have identified certain uses like this as one where we think it might work in this district, but we want the BZA to look at this specific application and see if this one works, right? Is it the right intersection? Does it have the right screening? Is it 24 hours or is it 12 hours operation every day? So that's where you come in. Again, that's a conditional use. So in those situations, variances, conditional uses, I would not recommend that the board make a decision about someone's standing to comment in front of you.
We don't.
Great. Because that's, again, a highly technical.
Much as I'd like to at times,
Right.
we don't.
Right.
Because, and you talk about a conditional use, we had a live one 3 years ago where a gentleman down here, and it's rural, I think this is rural residential along Old 3. He was running an exercise training studio.
Okay.
And he came to us for a conditional use permit so that, because his garage, he was using as a training facility.
Mhm.
I think he pissed off one of his neighbors.
It's usually how it happens.
Yeah, it's
Yep.
usually why it's here.
Yep.
And And so he came to us for a conditional use permit so that he could use that garage as a training studio as basically as long as he wanted to. But once he was finished with it, it didn't attach to the property, it attached, the variance attached to the use.
Mhm.
Which we don't see a lot of those, but that's the most
No use, home
recent one I
occupation.
can think of.
Yeah. Yep. So my recommendation, to confirm what you've already
Sure.
said, is that we don't, the board not make a decision, you know, whoever's in the audience, we're not gonna say who gets to talk or not talk.
Right,
Legally, could you? Yeah, there's a world where you make a decision with each and every speaker, whether they're close enough, impacted enough, affected enough, reasonable enough, I mean, any of the things.
sure.
But A, you're gonna be here all night if you're gonna start doing that for each and every person. B, you're not gonna know till, I mean, let's be honest, you're not gonna know till later. They're not gonna think of their best argument of why they have standing until later. And if you've already told them, no, they can't participate, now we've got a problem, right?
Right, and that's why I've always taken the approach, since I've sat here in the middle, I've always taken the approach, I'll let them talk.
Yeah, that's my
I will-
recommendation.
You know, we give them 3 minutes, they can do whatever they want with the 3 minutes, and then they're done. And then, we were told a couple of years ago in training, and you probably remember this, is that we can give them, based on their proximity, based on their argument, based on a bunch of factors, we can give that a certain level of consideration, which is easy for
Sure.
me, because that's basically what I do all day, is what level of consideration
Yeah.
am I gonna give these
Persuasive
sales?
value.
Exactly.
is what I call-
And
what I think
so
of it.
it's important that the guy that lives 15 miles away from the subject property, I'm probably not gonna hear as much as the guy that lives next door. Even though I'll hear their 3-minute, whatever,
Mhm.
tap dance, juggling act, I don't know. But that, and I think that's when you talk about allowing people to speak at public hearings, I think, and I've always thought it was important to let them talk, and we, up until a couple of years ago, we never really had a lot of public comment. But now, as, you know, the land gets filled in more, there's more people that are coming to the township, they want to do more, of course, we're seeing more cases.
Sure.
And it's kind of one feeds on the other.
Of course.
And then you get people that aren't impacted by our decision whatsoever coming in and saying, well, you know, I always appreciate the ones that come in and say, well, you should just enforce the code. That's what you're here to do.
Right.
Well, I could have just
We
sat
are,
home
that's why the
and watched
applicant is here
whatever
applying
on.
for this.
Exactly.
Yeah.
So, and I think it's important that we keep in mind how they're impacted by your decision.
Yeah,
So-
like I said, I call that, for me, in my mind, I call that persuasive value. It's like the weight,
Yeah.
like you said, the
Yeah.
weight you give it. There is absolutely nothing wrong there. That's a great way to think about it.
The chairman has been very generous as far as hearing people out. I think he's handled it really well. The
Oh,
thi-
I've been criticized, by the way, for being too
But
generous.
From my experience, but the thing that I read in your notes that you gave us here was A, time limits, and B, cross-examination, all right? We do put time limits on, and it says not to put time limits on.
I
And-
wouldn't.
And we can talk about that
Sure.
as an item. The second item is cross-examination, just because I don't think a lot of the people that you and I have in mind
Yes.
would do very well under cross-examination
Well,
if we were to ask them as to their
I don't-
interest.
I don't
You
think
know?
personally, I don't think there's any benefit. Maybe the next guy sitting here might. I don't see, in a lot of cases, there's a lot of benefit in it. However, with that being said, if a applicant is sitting there and somebody comes and raises a legitimate concern, rather than engage in a back and
Yep.
forth tennis match, I would rather intercede and have them address, if there's an issue, I'd rather have them address the issue at hand, and then move on. And in years past, we've handled it a few ways. Like I said, we went probably for years and never had public comment at all at any hearing.
Sure.
This has just been the last few years, and I don't have a big problem with it as long as it's constructive. And I think that's why we've, you know, you may or may not have seen the language in the meeting script that I didn't read because it's not relevant tonight, but we have that in there so we can A, limit it, and B, evaluate it based on its relevancy
Right.
as well. And I think that the relevancy for me is the most important
Sure.
thing. So if you're
Completely.
gonna get up and you're sitting over there and you're gonna get up and say the same thing that the guy in the third chair is sitting, you know, it's like, my hearing is, my wife says it's a little deficient, but for the most part, it's pretty good. It's good enough. And I can usually catch these arguments pretty quickly,
Yeah.
so.
Some of the people that come here, I fear that if they did not have a time limit, that they would use it as a, you know, a live blog
Yes.
for their concerns about everything relating to us, the chairman, the director, I mean, everyone. And I mean, I see the value in time limits, but I was wondering why that was in there, and I'd like to understand the thinking with regards to
Of
that.
course. The shortest answer is that any limitation, I mean, it'd be legally, it's not in a different category than telling them they can't talk at all. Now, it's different. I'm not disagreeing with that. But when it comes to a court case, a court is going to look at any restriction on the ability of a speaker to speak in the same way.
Mhm.
Were they kept from being an interested party and sharing their concerns? Right or wrong, good or bad? Should someone be able to get their burningest concerns into the first 3 minutes? Well, sure. But do they always?
No.
No. So the risk is that anytime you cut someone off or keep them from testifying, at least once, that you have put put a limitation that they can then challenge later and say, court, I wasn't allowed to speak. And you're going to say, yeah, you were, you got 3 minutes. And then they're going to tell the court, yeah, but I had 3 minutes more. And they didn't let me keep going.
Mhm.
Only a court is going to be able to answer that question. But again, my job is not to keep you from getting sued, but to put you in the best position if and when that happens, that you can say, we did everything that we could have done with the facts we had, the information, the records, the resources, that the law, what else could we have done? And so to eliminate that risk, that's why I say, don't put a time limit. I think you can do a number of non-time limit things that sometimes help. I won't say they always help. They don't. You might have someone who it's their personal podium and they're going to say whatever they want to say. I can't. None of us can change that, right? You can have, do you have people come up to a podium and address the board?
Yes.
You can create some of those formalities. And again, you get to decide. Where I was going to have a piece of this conversation too is this just Jen doing her one patio setback, low level thing, one person in the audience and they're in her favor? And, you can read the room and see how much formality do we need to impose on Jen, who's who's being very cooperative, she's not raising a fuss, versus a hotly contested, room's all full.
Right.
I usually say all the formality for something like that, right? The volume of people who might be impacted so as to be mad enough on either side
And
could be higher.
the other, and I'll throw two other things out there. Number one, our rules of procedure
Great.
define 3 minutes, number
Oh,
one.
I see.
Number two is everybody gets 3 minutes, and that's it.
Mhm.
It's not that we're singling anyone out and not giving them an opportunity, to speak, but they all get equal time. So,
Yeah, I understand. I mean,
understand your
yeah,
point
I know.
very, very well.
I know.
But I will be here until the 10th of tomorrow if we let some people speak that have no standing, in my opinion, and they don't have a dog in the fight.
It's the public witness equivalent of a heckler's veto. Someone could sit up here and essentially use up all the time that we have to properly do this stuff and would do it for purposes only known to themselves.
So in those situations, I would do a couple things. I would tell one thing I do on a regular basis is I tell the room, we're going to give everyone their time. We've already been here for, however, an hour. Rest assured that if your comment is the same as the prior person, if your comment has already been made, I don't like it, it's too busy, there's too much, whatever it is.
Right.
Rest assured that we have heard that. In the interest of time, we would appreciate the limitation of redundant comments.
Well,
Sometimes
a township, that won't work. here.
Okay.
I've been to these meetings for 20 years, and I can assure you that doesn't work.
Understood. The other item is, if someone is truly off topic, shut them down. If they're not on topic of your case, if they've launched into 3 others, they're done. They're done. You can tell them, because it's me, I would give them one friendly warning, Ms. Smith, we've heard you on a number of topics. We're here only on this one.
Right.
Limit your comments
We've
to
done
just
that.
this case.
We've
I mean,
also done that, and that's somewhat successful, but sometimes people enjoy the sound of their own voice.
well, and if they don't listen when you tell them that, I mean, this is gonna sound harsh, but see if the police officer can escort them out.
I have never.
I mean, if they're gonna disobey a direct
Right.
order from the board who
I have
has other
never
business, they can
experienced
go.
that in either a zoning meeting or here, but I have had one person that I've told to leave in how many years? And that was just a couple of years ago. And otherwise, we thankfully haven't had to go there. So, because that person left voluntarily, so.
Yeah, so those, I hear you. I hear you about the 3 minutes. I can only tell you what my recommendation is
Sure.
and give you, I hope, some tools. I mean, again, some of that is, I have seen good things happen, when the board or whoever, I mean, if legal counsel's there, whoever, I'll be the bad guy. I don't care. I'm happy to do it. Ratchets up the formalities. Sometimes that, again, I hear you. You have folks. Everybody has those folks.
Do you want to, here, I do this with my best friend all the time. New topic.
Okay.
Let's talk about Duncan versus Miller.
Okay,
and
we
doing the
can.
Analysis, and because that's kind of a big piece of what we do. And so I think it's kind of done and maybe not necessarily understood.
Understood.
So-
Yeah, sorry, yes.
I used to be the guy before I sat here, and when I sat all the way down at the end, I used to be the Duncan versus Middlefield guy. Once you do it about 100 times, all of a sudden you understand it pretty well. So,
Okay, these start on, by popular request, these start on page 6. I will go back a half a step and tell you about the 2 kinds of variances that some might be asking for. Duncan v. Middlefield is one kind. It's called an area variance. Think of it like, that's gonna be most of them that you see. Think of it as anything that,
98%.
anything that has dimension is usually how I remember it. I
Oh,
mean,
yeah.
more or less, right? It's a setback, a height, a depth, distance, lot coverage. That's an area variance. Why it matters is lower standard. The Duncan versus Middlefield factors are a lower standard. Practical difficulties. The other type of variance is called a use variance, which is what it sounds like. Jen wants to operate a manufacturing plant in a residential district. She's gonna ask for a use variance. She'd be wrong, she'd get denied, but she's gonna ask for it, right? And the reason that standard is higher, unnecessary hardship, is because what Jen should do in that instance is not ask for a variance. She shouldn't get permission to change one. She should rezone the property, right? So the standard shouldn't be easy. It should be high because she should have to show, and I'll start with that one. Basically, for use variance, she should have to show more or less that takings pattern that we were talking about, that she can make no other use. She can't rezone it for whatever reason. These are few and far between, and because of the height of that standard, should almost always be denied. So unless someone can really show you, this is the only thing I can do, and I've tried everything else.
We actually had a case like that 3 or 4 years ago. You remembered, and we denied it. And they went to zoning, and it was approved at zoning because they just rezoned the property, which is exactly
What they should have done the first time.
And they were
Agreed.
told that.
Understood, I'm
And
sure,
they-
I'm sure.
I've heard, the one thing that I've heard here, and this is kind of an aside, the one thing that I heard here a couple of times is that we asked an applicant at one point, why are you coming to us and not getting the property rezoned? And I don't remember if you
That's a
were
great
here yet.
question.
And the applicant said, and I quote, because we heard that the zoning appeals board was easier to get
Ooh.
something approved than the zoning committee. I don't think you were here yet, Paul.
Oh, goodness.
And
That's not a good reason.
boy, talk about turning those friends right down.
Yeah, that's not a valid reason.
Yeah, no kidding.
Yeah, I'm not telling you anything you didn't
I'm
already
pretty
know.
sure that night, their application was denied five
I
to
bet,
5.
I bet.
But you're right. In cases like that, I have seen a few over the years, and those are 2 of them, that I can think of, that it is amazing to me. I'm sitting here listening to them thinking, why aren't you up in zoning? Why are
Right.
you here?
Right.
And
And they
I
should be able to
know-
answer that question
I
if
know
they
staff
intend to
makes
get past.
best efforts to get them to go to zoning. And sometimes people just won't. So if
Yeah.
they don't, then they can come here and take their chances.
Yep.
So, because this is like, no, never mind, go ahead.
So that's use variance. Again, higher standard, undue hardship, almost always denied. Changing some piece of the, again, like the actual, like the activities that are occurring on the property. Okay. Second type, area variance, height, depth, width, height, or I said that one, coverage, distance. And these are, again, most of what you're gonna see, 98% at least. In case law, so we don't have, the standard out of the law is practical difficulties, and undue hard, I mean, it's that magic language, and as you can imagine, courts worked for the next 20 years to figure out what that meant. The Ohio courts landed on, again, the Duncan standard, Duncan v. Middlefield, it's a case, right? Duncan versus the city of Middlefield. I heard recently that from wherever Duncan lives, he's still alive, and he's most recently, what was this case? He's back into the courts, I think trying to use an HOA reserve that had a drainage, like had a pond on it, for a residential lot, because he is gonna have a houseboat. I can't. I was presenting on that case, and someone in the audience was like, yeah, it's Duncan of Duncan v. Middlefield, and that you could have picked me up off the floor. I couldn't believe it. Yeah, so anyway, just food for thought. Okay, so the standard for Duncan v. Middlefield for an area variance is a test of 7 factors. We will have these beautiful 7 factors, and I will cut to the chase, and we will go through each one, but I will cut to the chase and say, they don't have to meet all of them, they don't have to meet any of them, and you can come up with other factors that aren't on the list. So to actually,
We have had a few over the years that meet very darn few of them.
and that's
And
okay.
yet their
They can
applications
meet
are-
all of them
Yeah.
and be denied.
Yeah.
They can meet none of them and be granted. There is no, that's what, non-exclusive. They don't, and I've had lawyers argue this to me in briefs, in court. Oh, this application only met 3 of the 7 factors. And so by this lawyer's logic, that wasn't 50% of the, there's no,
At that point, what's the number?
yeah, but there's no law that says
Right,
they
what's
have
the
to
number?
meet
3, 4,
even
5,
one of them.
7?
Right,
Yeah.
but it is, that's right, thank you. So let's go through them one at a time. And lots of this is legalese, it's straight out of a court case, I didn't make this up, but we'll talk through it. So first, whether the property in question will yield a reasonable return, or whether there can be any, meaning like in its use, can it be, or whether there can be any beneficial use of the property without the variance. So let's take a typical, I don't know, I mean, pick your poison.
Let me throw you a bone. Generally, the answer to that in here is yes. It can
Oh, yeah.
have beneficial use
Right.
without the variance.
Right.
Almost always.
Right.
I can't think of many that
So let's
can't.
use, I'm going to give it a hypothetical just because I think it gives us something to chew on when we go through these. So let's pretend it's someone asking for an accessory structure that's bigger than you allow. Yeah, or a second, or whatever, a more
Yeah,
accessory
a second
structure
one, we've had a couple.
than you allow.
Mhm.
So first question, whether the property in question will yield a reasonable return. Well, yeah, they can still use it for their house, right? I mean, residential, except they can use it for their house, whether they have 0 sheds, pool houses, second, third car garage, whatever. Like it can be used for that reason, the residents, with or without the variance you give them, right? So like you said, the answer is yes. It can still be used for those even if you don't grant the variance. Second, whether the variance is substantial. This is the only factor in this list that you have any kind of objective explanation on. And actually courts that have looked at this question have said that a variance is substantial if it is like 25 to 30%
Yeah,
increase.
We've been using 25 because the
25 to 30%
the county
of an
prosecutor
overage.
told us a couple years ago that anything over 25 should be
Yeah.
considered
Yep,
substantial.
and there actually is a-
really, It doesn't, I mean, and there again, we see them 50, 60%. but
Right.
It depends on all other,
Right.
that's not a reason to deny
Correct.
or approve.
But it can be,
Can be.
but it doesn't have to be. So
Right.
I do have, folks, it is tempting, I admit, to have one of these factors be the black and white factor, right? Either it's 25% or it's 24%, we can hang our hat on that. Don't be tripped up that that is the only, I have boards that get sort of tunnel vision. Well, it's 26%, so we can't grant it. Not true. It just goes into the pot with all of the other factors,
Right.
all of the evidence you hear or receive, and you weigh it that way. Again, don't be tripped up by just that factor. But so say the accessory structure is, like you said, 50% bigger than it's allowed to be. That would be you would say, yes, that's substantial. Again, doesn't have to be the nail in its coffin, doesn't have to be the thing that gets it denied. Does make it substantial, and that's okay. Okay, so 3, whether the essential character of the neighborhood would be substantially altered or whether adjoining properties would suffer a substantial detriment as a result of the variance. So using my accessory structure, garage, whatever, 3-car garage, whatever, 2-car garage, detached. If everyone else in the neighborhood or 3 other people or their next door neighbor has the same thing, this is where you would say, oh, well, it's in harmony with what's next to it, right? No one's gonna drive through this neighborhood and go, oh no, what is that? What is that monstrosity, right? Oh, there's a garage, there's a
Huge
garage there.
one For me, that one is the number one
Right.
thing. Does it change the neighborhood? Because if it does, then I'm really heading down that slippery slope of no. Because that, like I said, that for me is the most important factor in Duncan
Important one.
versus Middlefield.
Yeah. Sure. So, and this is where I think you're gonna hear, this one gets a lot of testimony. People don't say, I would like to testify on whether the essential character, but if they're coming in and saying, I don't have a problem with it, my
Yes.
neighbor next door has one like this and someone across the street, and we don't even think twice, it's our kind of neighborhood. Versus someone who's coming in and going, it's not even gonna look right anyway. And we get those too, right? Probably not for an extra garage, but I've had some for home occupations, landscape company home occupations, it's just its own
But what I
special.
think
It's gonna
the
ruin
most
our neighborhood, it's
is
not gonna
that
look right.
They want to not have a garage. And, okay, it's like, well, I want to turn that garage into living space, so now you're not going to have a garage. Well, for me, that changes the essential character of the neighborhood, because you're going to be the only guy that doesn't have a garage, potentially.
That's interesting. I'm not even sure that's still an area variance, honestly.
Might not. be.
Might not be, anyway,
Might not
that's
be, but
that's an interesting
it is, yeah.
hypothetical.
You know,
Everybody good on that one?
Yep.
Neighborhood? Whether the variance would adversely affect the delivery of governmental services, almost always it doesn't.
I can tell you, I've sat here long enough. We had one case when I first came on the board where there was a condominium community, detached condominium community that was built in the township, and the builder screwed up, put the slab too close to one property, instead of being in the middle of the two, built it too close over here. And they didn't find out until the property was constructed that it was too close to the one next door. And I will tell you that that was the one and only time I've ever seen somebody from the fire department come in and sit at that table and say, we cannot get our equipment between these two houses, and so we think you should turn it down. And the board, not me, the board approved that. And I thought that was dead wrong, but I still only get one vote. So, as it turned out, the other 4 thought it was just fine. But but that's the only case I've ever seen like that, for police and fire.
Yeah.
Generally, we never get a comment.
It's pretty rare. I don't know if I could give you even a good example of when one, yours is better than anything I could come up with. Water, sewer, garbage delivery, or garbage pickup. No, that's never the truth. Okay, whether the property owner purchased the property with knowledge of the zoning restriction. They're almost always going to tell you, no, they had no idea. They did not know.
And we always tell them, you did know.
It's okay that they say that, right? I don't think anyone's up there lying. I just know that people
Right.
aren't aware.
Ignorance of the law is no excuse in here.
That's right. They are on notice of your laws. Your laws are of record of the state. They're on the website. You
Yep.
probably file them either with the recorder or records or all of the above. They are on at least constructive notice of the laws that apply to them, right? It'd be no different than if I were going down the road and I said, "Officer, I didn't see the 25-mile-per-hour sign." I guarantee you I'm getting that ticket.
100%.
Again, ignorance, not seeing the sign is not a defense.
Right.
Not reading the code for your own self
Yeah.
is not a defense.
Related to what they were calling self-created variances, needs for self-created variances by asking for a change that was already, where code already forbade it for all intents and purposes.
To a degree, I mean, lots of variances are really self-created, right?
Yeah.
I want a patio that's bigger than I had before, but coming to the variance versus needing it for yourself, I mean, is a distinction. I think those would go to, again, persuasive value. Did Jen just buy a property and really the prior owner made the problem? I think you absolutely can take that into account
That all the time.
versus she's just trying to, get more outdoor play space for her kid, whatever it is, right?
As a general rule, if somebody comes to the table asking for forgiveness as opposed to asking for permission, should we think about those differently as a board?
I wouldn't use that as the single reason.
No, I'm just
But-
asking
but-
your opinion. 'Cause
But can you, right, I wouldn't hang your hat on that. I don't
Yeah.
think you should deny on just that, because
Uh-huh.
lots of people come in for forgiveness
Yeah.
later.
Because let-
Can you weigh the persuasive value of that? Do they think they were telling you the truth when they said, "Oh, we didn't know," and we just went ahead with it? Or are they I have had lots of contractors come in and say, "I didn't know." I'm like, "You didn't know, this is your job."
Permit was the problem, because we used to get those a lot, and and you're right, it's not a reason to approve or deny, but are you realistically, as a board, do you want to sit here and vote against a guy that just spent $8,000 on a fence? You really want to vote against that fence that really otherwise generally meets the rest of the criteria?
Well, yeah, and to your point, are we trying to, and I don't mean this the wrong way, but like, are we punishing
Right.
the person who was really at fault or not? And that's fair, but I think there's persuasive value in it, I do have folks who come in to ask for forgiveness, and you're like, should ask for permission. So can you deny a variance in that situation? Of course. Would I have that be the only reason? Probably not. But usually these fact patterns, it's usually not the only reason, right? You went too far. You had lots of opportunities. You thumbed your nose at everyone. You're doing something way so different in your neighborhood that you ought to know, you should have known, right? There's a reason that no one else has a 3-story a 3-story garage. You know what I mean? Like, there's usually another factor than just, I didn't know. But I think all of that can go into the analysis.
Basically, it sounds like what Duncan really did was ask you to balance across multiple criteria as
That's right.
opposed to use a simple rule,
That's right.
right?
Like most courts, they took a 2-word standard and made it into 7 beautiful factors, right? So that's right. We're balancing all of the things. What are all the main big ticket items that go into deciding, is this variance a good idea or not?
And the court rule essentially says that we have to consider them, but we don't even have to use them at
Correct.
the end of the day.
That's right.
Which means that if we consider them, then we're legal, even if we make a decision based on something completely different.
That's right. They have
That
to
was
get-
something that I had no idea about when I
They have to
started
get
this
thrown
job.
into the pot, but if they're not the thing that wins the day, it's okay.
Yeah.
Yeah, and case after case has said that. I'm gonna hit the last couple. Whether the property, this is full legalese, and I apologize for that, again, court language. Whether the property owner's predicament feasibly can be obviated through some method other than a variance. Can they fix this another way? Can they move the structure? Can they position it somewhere else that it doesn't need a variance anymore? Can they reduce the size? And these, to me, if I were in your shoes, this would be my question. What else have you tried? What else did you look at? What other options did you explore? And why did you end up with this one?
So we get driveway expansions a lot.
I'm sure.
And so like, the code doesn't allow for additional parking like that. So in order to add that, you'd have to get a variance. Or you can get you can get zoning clearance to add a walkway or something like that. So you can't utilize it to park, but you can keep the concrete that you've paid for by saying it's a storage for trash cans, it's a walkway. Instead of getting a variance to park on, you can keep it by going that route.
I see. That's here or the, or city code?
City of
Oh,
Columbus.
okay,
Yeah, yeah, yeah.
okay.
Yeah.
Yeah, I have, have seen that for sure. Yeah, so those are my questions. That would be the question I'd be asking. What else did you try? Because they're supposed to have tried other things, and probably they've talked with staff and, and if they say, well, we talked to staff and we didn't have any other options. Okay, you didn't. I mean,
Yeah.
what did you think about this? Or why didn't, and out here, I don't know how many times a month I hear, well, actually the septic is right there and so I can't move it. That's very common. And that, to me, that's a good reason, right? You can't put it on top of a leach bed. I get
We
it.
had a guy with, that had electric running. In fact, I drive
Yep.
by the house all the time, electric running.
Yep,
across
high
the
voltage
back of the
lines,
house.
easements all across
Yep.
the back. I mean, there's lots of really valid reasons for why. I think getting those on the record is great. I mean, that's a very fair question. And to me, that goes a long way to knowing that someone isn't coming here, again, just asking for forgiveness and they didn't try anything else, or this is their path of first resort. Try other things. They probably did, right? They didn't hire a contractor and just say, oh, do it however you want. They probably
Just
got
put it out there.
they probably got a number of options and they
Yeah.
talked through and, well, that's not what we want and here's why, and that's not gonna work and here's why. Let them tell you, right? Have them tell you, put it on the
Also
record.
drag the contractor in to tell you why.
I'm
what they
sure
tried.
that's right. That's right. Make him
I think
tell
it's
you.
great. The contractors that send the homeowner in by themselves, those are the
Oh.
ones that, yeah, fail quickly.
Right. And then last but not least, whether the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting a variance. For this one, I usually make myself sort of zoom out and say, why do we have that requirement? Why do we say that you can only have 1,000 square foot of accessory structure? Well, because we don't, and again, I'm off the top of my head. Well, because we don't want everybody's backyard just gummed up with garage, shed, garage, pool house, kid playhouse, blah, 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 Okay, well, that's one reason, we want there to be oversight. We want there to be consistency, harmony, right? We want people to use their backyards and not just have it be, okay. So then this one that we're asking for, does this application still meet, again, this is just one, do we still have that, even if we grant this variance? Is it harmonious? I mean, it goes to a lot of the other factors on the list, but are we just, we might as well have not even had that section in the code, or are we still being true to it, even with the extra permission? And again, all of that's gonna be very fact specific, right? It goes, I'm gonna point to another factor. If everyone else in the neighborhood, it's like, well, but we haven't destroyed the neighborhood. We haven't destroyed the restriction. We're coming in. This person explained what they want. They're not running a business out of the new structure. They're going to use it for household storage and the storage of an additional vehicle, the usual stuff. Nothing out in third base, right? I mean, pretty normal. So to me, that's the factor that you kind of zoom out and say, are we still getting the benefit of this provision, even if this person wants something different? And then again, like I said, taking all of them, do they meet some of them? Do they meet none of them? It's entirely up to you. And then taking this opportunity to talk about how we incorporate these, there are probably a million ways to incorporate these into your motion. I have one board that works off a worksheet, and they work through them one at a time, not as the motion, before they do the motion. They work through them one at a time, and the chair says, well, guys, what do we think? Does the property in question yield a reasonable return, or can it be used without the variance? And he looks back and forth, and they say, yeah, it can. And he gets that on the record, and I think he usually writes it in his cheat sheet. Okay, guys, what do we think? Is the variance substantial? And they go, well, it's 30%, so yeah. And they agree, yes.
The takeaway here with these 7 is you have to look at them, but some are more important at other times than other ones are. So you just need to hear the whole story and take all 7 into account if they apply.
Absolutely.
Okay, got it. Okay,
Yes.
just wanted- we're
Of course.
rehashing, so I just want to make sure you're getting that.
Absolutely. So then what I'm saying too, though, is we want to get that on the record, right? It's not enough. Again, I have lots of boards who keep it in the back of their minds and never say it out loud. That's not going to save you, and here's where I'm going to say this part, that's not going to save you if you do get sued, because what's going to become the record of your decision is going to be the minutes of your meeting, any recording, if you record, and your, the decision itself, whatever that ends up being, a motion, a written decision, all of the above. If you have an analysis and it never comes out on the record, it's not going to be part of the record and it's not going to be considered by the court.
Which we
And-
don't do.
And the court's not going to know, so again, if you were appealed to the Court of Common Pleas, which again happens all the time, not a scary thing, the court is going to look at the record, what we send up. They're going to they call down here, they file something, and you have to prepare it. You have to file it with the court. If the court cannot tell from the minutes and the recording and the decision what you based your decision on, again, my worst case scenario is not that you get sued. It's that they could open up the record, take new evidence, and then send it back to you to make a different decision. To me, that's not fair. The decision of the community should be the decision. But if the court can't tell, the standard is whether the decision was arbitrary, capricious, or against the manifest weight of the evidence. If they can't tell from the decision what was considered or not considered, they could decide that they don't know what, maybe it is arbitrary, capricious, or against the weight. So the more you can put, what I'm encouraging you to do is the more you can put your analysis on the record, the better. If that is, you run through the cheat sheet, you run through the factors, and then when the motion comes, you move to approve based on our findings of fact, even if all you say is, Mr. Wilcoxon, I agree, I think it's substantial, but I think it is in harmony with the neighborhood. We've heard even if you hit a couple of the factors that made the case for you, or no, I'm denying it because it is substantial. And I do think they could have tried another option and they didn't. And you could say, and so for those reasons, I'm voting no. Even if you put some of these on the record, you've now given to all the world your insight, your basis, your analysis as to why you made the decision you did. That's a good thing. So I'm not asking anyone to go into a treatise of, well, Ms. Huber told us we had to run each and every one all the time, yes or no, yes or no. But the more you put on the record, the better that will be when a court has to look at it, because they won't have to imagine what the analysis was. They'll have it right there. Okay. We've sort of gone around a number of places.
Can I ask
I'm
a
happy to
question on
take.
variances one more time
Of
before we
course.
go? We haven't dealt with any use variances while I've been here?
No.
I didn't think so. I wanted to ask about that because technology is making it easier and easier for people to do different things, more so than they have in the past, particularly things like a new app that I've heard of called Sniff Spot that allows to turn your property into a micro renting dog park. So let's say you have 3 acres and it's fenced and you could make a lot of money doing that. And I'm already using these in unincorporated places for my dogs.
Mhm.
I was wondering what would happen if someone within a given development chose to use their home for alternative uses like running a business as a private dog park. And was that something that would potentially come in front of us? And what would be the guidance? Would it be the township code with regards to what a residential house could be used for? Or, because I've been using these things and loving it, and I'd hate to find out that I'm creating a problem in the process of,
Sure.
of enjoying it.
Great question.
you know?
I think these technology related, they're so fascinating. I have one, not to go afield, and I'll be brief. We have one, there's a version of that called Swimply, where you can rent out your pool, just your pool, to
Yeah.
someone. That is making a number of people very upset in the Pickerington area.
Of course.
For this one pool. They're also being fairly disrespectful about the way they're doing it. But anyway,
Yeah.
parking, noise, the conduct of the guests that then come and leave in any given state. So interesting, fascinating to me that as we see more and more of these things. That, I suspect, please correct me if I'm wrong, would probably be treated as a home occupation in the township, assuming it met the home occupation threshold and didn't reach to a level that is, again, beyond a home occupation, meaning a business that you're operating at your house in conjunction with it being a residence. in home occupation land, it has to be first and foremost a house, second and much lesser, a business, right? If I took a client at my house, or if I was an accountant and during tax season, I prepared a number, and I had customers at my house twice a day for 2 weeks right before the tax day. Probably, don't quote me, but like depending on how your code is written, that would still fall in under a home, could fall in under a home occupation. If it exceeds it, Jen's running a full doggy daycare, spa, training, there's a limit, right? Because a home occupation, the concept is, in a perfect world, it's a business that if I were operating it in my house, you might never know I was operating it in my house. That's a traditional home
So
occupation.
that's not the same as having packs of dogs running around
There's that.
all the time.
So if they
you
don't
know?
meet the home occupation, it may be that they're operating outside of that threshold. If they are a home occupation, I think you probably use them as, or the conditional uses at a certain point.
There's some home occupation standards that if they hit those, they can just apply the
Like
home
a lo-
occupation
like a
permit.
low level.
But if they're outside of those
Yep.
standards, then they'd have to get a conditional use to be able
Okay.
to.
So let's pretend they are in that
Mhm.
higher level, then they would come to you for a conditional use permit.
I see.
And you would apply the standards and thresholds of the conditional use provisions, whether those are general conditional use related or specific to this kind of use. I think we're gonna continue to see more and more, post-COVID, everyone's running something from their house, right? Or they were before and it's just gone, and right or wrong, good or bad, I don't. But the way we've regulated.
Yeah,
And
for
the
sure.
side that just, like my neighbor, she does little crafts, and she doesn't really do that.
Well, it has real world impacts because, I could potentially start a sniff spot in 2 seconds and that literally have people cycling in and out where my neighbors would have to deal with the traffic. People who don't like dogs would have to deal with more than just my dogs on a
Sure.
regular basis. There's liability concerns, and I can imagine a pretty gnarly situation where this person is in a hardship financially and needs this income to do it. And we would have to potentially weigh all those factors as part of whether we would grant a variance. And I think it's getting tricky because, the more we're seeing like the logistics of that play out, vehicles around, delivery trucks, delivery in, delivery out, it's becoming a challenge. But I don't want to derail. I just wanted to make sure I
Fair.
understood the issues.
It's absolutely fair. I think, again, I put that in a similar of like anyone renting anything out, right? Some of the Airbnbs, some of the Swimply, like if you can rent it, people are renting it out on the internet. I hope that massive corporations like Airbnb and VR,
Yeah.
that they are hopefully giving some resources, given the volume around the country I assume that everywhere these are operating, someone probably has a zoning regulation in place. Whether they've caught up to the the B&B or not is a question. Columbus has significant Airbnb regulations for.
It took a while, though. and
I'm
then
sure
they
it's it.
finally
Yeah,
licensed
they're
it,
recent.
and
The last 3 years or so, right? So again, my hope, probably naive, is that Airbnb corporate is saying, hey, Jen, before you open an Airbnb, make sure you check with your zoning regulations. But I'm sure they're not following up on it. So I think you will see things like that as we can, that's our world, right? Everyone's probably used some form of rental something somewhere,
Yeah.
or more and more every day. So I think that is going to continue to happen. And I think you'll, again, use your factors, use your criteria. And some of this goes back to the legislation itself. As with anything, the more issues you're seeing, the more questions you're getting, all of those go, I suspect, on a staff list of, hey, next time we're running a amendment to this code, maybe that's somewhere we put some attention. Whether it results in an amendment or not, maybe we need to think about it. Again, Columbus with their Airbnb regulations. It went on a list. Teams, I'm sure of lots of people, looked at it, focused on it, pulled samples from elsewhere, and came up with a plan and a way to address it.
Thank you.
Of course. I want to take a couple minutes to talk through the ethics, and I'm not going to go too far into the weeds. And this starts on my pages. On page 12, in the middle of page 12. My rule of thumb you are public officials, right? So you can be in a position that you have a conflict of interest with a case that's in front of you. I hope that never happens, but it's okay if it does. That, right?
Any of our neighbors could.
Of
ask for-
course.
Yeah, right.
Well,
things
I
like that.
hope it's never a problem,
Yeah,
but of course
right.
it could happen. Absolutely. And the issue is only how you handle it and being aware of it. If you find yourself in a position where you know you have a conflict of interest, you're too close, you can't be objective, whether that's a true legal, straight up, it's your daughter's application, you know you can't be unbiased, right? You need to recuse yourself from the whole hearing of that case. You can't, my advice is that you not sit up with the board while you do it. Because the public, even if you say, I recuse, you wear a pin that says, I recuse, the public still sees you up on the bench, thinks, that you might still have some leeway. And so if you're going to recuse, my advice is that at least you move yourself out to the audience if you still want to participate in some way. And if you can just go sit in the car because you don't have a dog in that fight, better. Because again, people who get hotly big feelings about a given application are, again, in a court situation, and I've seen this happen, going to think of any reason, oh, well, somebody's up there giving baseball signals to the board on what to vote or not vote on, or they shook their head and that's why the board voted no. But not give them any reason to think that, right? No reason, if that's an easy thing. Now, that being said, you don't lose your character as a private citizen, property owner in the township. I cannot tell you that you're not allowed to participate in a zoning hearing, but just be very careful if that's the case. Again, not my preference, but just be very careful, make it very clear that you're not there as Mark Harmon, president of the BZA, right? You're there, private citizen all the way. You don't have any other rights or remedies than anyone else in the public. That's one piece I was gonna, if you're questioning whether you have a conflict, ask. I mean, I'm happy to talk to you anytime. Staff would be happy to point you in the direction, talk with you about any of that. Prosecutor's office would be happy to talk with you, any of the above. Ethics
Having a
Commission.
personal relationship with an applicant, is that a criteria for potential recusal?
Yes.
All right. Yeah, I just wanted to make sure that was clear.
The main question is can you be objective? And then goes down to, yeah.
I was saying, not just, can you be, like, I might be bordering and say, I can totally be objective, but if it's in any way perceived, or if anyone thinks, I don't really think you can be objective, I think for safety's sake.
Yeah, where I was gonna go with that was,
Yeah.
as a society, we've decided that even if you can say, oh yeah, I can, and you believe that in your heart of hearts, we've decided that you can't, when it comes to your family members, which is a defined term in the Ohio law. Generally speaking, it goes like down, anyone immediate relation, adopted or biological family members, any non-family member or distant family member who lives with you. So again, they might be your second cousin twice removed, but they live with you. Again, we've decided that those people that you spend your days with, probably you have a bias, because of course you do, right? Of course you do. Business.
What if you don't have a relationship personally or family with them, but you are both members of another legal association? Like if we're both in the same homeowners association or the same company or anything like that?
That by itself, generally not.
Okay.
If you are partners in a business, a business associate is coming before you asking for something related, like
Yeah.
if you're gonna get a benefit or a detriment that's another category. Are you gonna get a benefit, or keep in mind, a detriment out of the application being granted or denied? That's also, we've decided as a society, that's too close. You can't be unbiased. You get to recuse yourself. And then the catch-all, though, to me is what I always ask people when they say, well, it's my realtor, or I worked with them 10 years ago. My first question is, because again, neither of those falls into any specific category. But then even if it doesn't, my question is, can you be unbiased? I understand that. Thank you for disclosing that to the room, to the board. Can you still be unbiased? Can you be unbiased? Are you concerned that you can't be? And they answer, I can be unbiased. I can be objective. But again, you have to mean that. That has to matter, right? Because we can't have a situation where someone's like, I don't know. If the answer is, I don't know, I use this as sort of like a spidey sense or like a sixth sense. Like when people come into these situations, like if there is a conflict or if you're too close to the scenario, I usually say and if your answer is, I don't know, that should be your answer. If you think there's any question that you can be objective, then bow yourself out. No harm. It's not a bad thing. It's you being a faithful public servant and honoring your commitment to be an objective decision maker for the applications in front of you. Not a bad thing. But then, like I said, you can't listen to the testimony and then pop yourself out. You need to be recused from, be
Oh, no, I had to
recused.
go sit in a conference room for a couple hearings.
No,
so
that's
yeah, so
fine.
yeah,
No, I
yeah,
have
yeah,
had
no,
folks,
I
I
get
have
it.
had folks tell me, like, in private deliberations, oh, they're actually my next door neighbor, and we go to church and breakfast every Sunday morning, and I'm like, you waited this whole time? This whole time? Don't tell me that now. Okay, so that's the things I was gonna say about conflicts of interest ethics. Obviously, we could spend a lot more time on that subject. Any burning questions about that while we're here? One other grab bag item, I did just say private deliberations. Have you done that? Do you know what I'm saying? Okay. Obviously, very quickly, you have the right to do that. Don't let anyone tell you otherwise. You're judges. You sit as judges. It's not executive session. It's private deliberations. You don't have to have a reason to do it. It's just any reason. And the example I give is you can adjourn yourself to another room, or you can kick everyone out of this room and have your own, for those of you who are new, have your own conversation in here, just the 5 or 6. You can have alternates with you, would not have zoning staff, but all of you, legal counsel, can be here with you to discuss a case. I have had lawyers say, oh, you can't do that. That's an unlawful public meeting. Not true. Read the Sunshine Law Manual. You absolutely can have this. And again, the practical real-world example of this is the U.S. Supreme Court. We know that they hear a case. It's public. You can watch them do it or hear them do it. They hear a case. They hear arguments. And then they close everything up, and the next thing we know, there's a decision being presented. Obviously, they're not mind readers. They didn't just deduce what everyone was going to do, which is why we don't have 9 different, 7 or 9. Shoot, I should know that. Ohio's not, it doesn't matter. Ohio's 7. They talk, my point is, they have conferences outside of the public view to decide, where are we at on this case, right? And then who's writing the majority, and then who's writing a dissent. They talk about it. You can do that. We've decided as a democracy or as a society or whatever that the judges of the world need an ability to talk amongst themselves outside of the spotlight so that you can run through your analysis, decide where you're going to be. So you can do that in the meeting. You can kick everyone else out of this room or go into a separate room, talk amongst yourselves, come back, put the hearing back on, and keep going. Take minutes of that conversation. It's not public record. No one can come in. It can't be recorded. It can't be videoed. None of the above. You get the benefit of coming outside of the spotlight to walk through your analysis if you need to talk about it. If you have a sense that you don't know where the rest of the board is, you don't know what motion to make, you just want to talk about it. I have some boards that almost never use it. I have some boards that go into every couple months. They have a case that,
I think we've done it twice
Mhm.
on the same case within the last 6 months. Before that, we never had
Yeah.
done it.
It was
Yeah.
awesome.
Yeah, I know.
It's an awesome break.
It is. It is. And you deserve that, which is why I've had lawyers and other folks in recent months, they can't do that. And I'm like, for the 7th time, here it is. Here's what it is. So don't let anyone tell you you can't. You absolutely can.
I'm pretty sure that's in our rules of procedure.
Great.
too, So,
Great.
that we can.
All right, I will pause. We're at about the hour-and-a-half mark, so I'll pause here. Any burning questions? If not, I remain a resource. You're welcome. And
I have one more question, I'm
please,
sorry.
I don't apologize.
One of I studied philosophy in school, and some of the ethical stuff always comes up to me when I think about my role. And one of the things that we had debated a couple times in the executive session is if you see someone wanting to do something that is clearly a variance, then we run it by the rules and we do all that properly. There's also the possibility that by granting this, you have to assume what would happen in the event that it's perceived by others as now something that can be done, that would be worthwhile doing, since now we know there's at least an example of someone doing it.
Sure.
Is it really practical for us to think about the implications of ruling on a case with regards to how others might respond to it and create more requests for variances as a function of that, or?
Generally, sorry, I didn't mean to cut you off.
No, I got it out.
Okay. Generally not, because all of those would be hypothetical, even as
Okay.
sure as you are that seeing one is going to cause, and I was born yesterday, I know that that's a real thing.
Yeah.
But generally not, because I wouldn't have you play the what-ifs game as part of your decision-making. A
Got it.
case should rise or fall on the evidence and the testimony in front of you, and only that.
Marcus has given us this guidance in executive session. I just wanted to understand kind of the, more of the legal underpinnings
Sure.
for it.
Believe me when I said.
No, I totally believe you. I was just trying to understand the legal foundation for it.
The other, whenever anyone says precedent,
Yeah.
to me, the other thing I say is, it's only technically legal precedent if it is exactly the same situation.
And it won't be.
Yeah, it won't
And
be.
I have never seen the exact same situation, right? The lot configuration, if we're using resident, the lot
property
configuration,
is
the
the same.
reasons, the options they tried and failed at, it's not gonna ever be that.
That's
If
really,
someone
that's really
could-
helpful.
could tee up the same thing, I would say, well, let's have a conversation about precedent. It almost never happens. So
That's really-
highly case specific.
Because as a technologist myself, I tend to think of the fact that barriers to people communicating about what they've done and what they're doing have fallen so much that all you need is a big next door thread, you know? And then all of a sudden, everyone realizes that, well, look what he did with his roof. You know what I mean?
Yep.
And in that circumstance, you could very easily create a groundswell of interest in more variances as a function of that. And if we're not supposed to consider the implications of that happening, then we won't, I won't.
Would it?
What about considering like previously approved variances that they can bring to show examples of that are
If the-
similar to
If they're
theirs?
if they're applicable, if they're reasonable, if you do, again, persuasive value, if you do, lots of people do that. I'm sure you've seen that as well.
We've had that.
Lots of people do that. Sometimes they're on point, frankly, in my opinion. Sometimes they're on point, sometimes they're not, right? If they're 3 miles down the street, sometimes I say, I fail to see how that's, apples to apples. But can you consider that as, that probably to me in the variance context goes into the neighborhood, harmony, consistency with the surroundings kind of analysis. And I would say, yeah, that can be considered. Again, you don't have to hang your hat on it. It doesn't have to be the winner or the loser. Can you consider it? Absolutely.
Well, often when they say that, when they demonstrate that there's other stuff in the neighborhood, we don't know whether that was granted through a variance or
Sure.
if those were, we
If
don't
it's an
have.
active violation.
Yeah, right, exactly, yeah, so we
Well, there is
don't
that.
have the township take a look at, look at all the variances in the neighborhood and what were they, and nor do we ask, well, do you know
No.
if they got a variance? So it's,
Sure.
if they got a variance and it's sitting there and that's now the neighborhood, then, I don't care whether they got the variance, that's what the
Right.
neighborhood now looks like.
You're right. Every case stands on its own 2
Mhm.
feet, as far as I'm concerned.
Yeah.
Because every property, what I learned in my occupation is every property is different. So whether you've got one here and one next door, they're still different, regardless, absolutely regardless. So,
I had
Okay.
one other thing, if you could touch on motions, would you
Sure.
say possibly the best idea when doing a motion is to plan out the motion before going through it and having an idea of what you're gonna say as far as your reasonings, as far as
Yes.
what you're gonna do for your determination, and then read through the motion after that?
I would say
That's
that,
something.
yes. So I have boards that use scripts. I think they find scripts very useful. Yeah, right. Yours isn't incredible. I may steal it. But yes, I think that's good. Having a sense, I have folks that actually use their agendas or the public notice as the start of their motion. I don't know if that's useful, like a motion to approve case number 123, seeking a variance from, but yes, I think that's smart. I think it helps to, again, sometimes boards even rotate the motion maker. I don't know if or sometimes it's just whoever feels the most strongly. There's no wrong way. There's no reason that any one of you at any given time, anyone sitting, obviously the alternate sitting as the alternate cannot make motions, but anyone else can. But yes, I think solid motions that are consistent and keep everything together, have everything in one place are consistently done well when sort of thought of ahead of time. And maybe even if you get into more of a routine with how you, and again, depends on where you're at right now, what you look at, where you start, where you finish. Again, the board that I'm thinking of, they read the blurb from the legal notice. They provide any of the movements commentary about, on a finding that it's substantial or it's harmonious with the neighborhood or all the above, whatever. And then they always add some version of like as submitted or as presented, just so it binds the applicant to exactly what was applied for. But they follow that like clock. I mean, they follow that same process for
Pretty much what we
motions
do.
each and every time.
Yeah.
But yes, I think that's useful. The motion should be made by a single person, right? It should be movement, make your motion. If it gets a second, seconded by a seconder, then there can be discussion on the motion. If somebody says, well, what about this, Mr. Harmon? Did you want to add that in there? Did you want to add this provision? Or what did you think about this? Oh, yeah. And then you can amend your motion, get it re-seconded. I mean, there should be some formality in that so that it's consistent and hits all the marks that you need it to hit, and that it creates a very clear record for the case so that no one can come back. Again, it won't be us, right? It'll be 20 years from now. Someone's going to go, well, it says right here I could do X, Y, or Z. Like, let's have it say that so that the people who are doing our jobs then don't have to guess.
Okay. Anybody else? Anything for Jen? This is it. You won't see her again until.
No,
we have-
I'm gone. That's it.
Do
have a
do we
big
have
problem.
access to you via email, or does it have to be funneled through the chairman?
I'm happy to be contacted in any form
Oh.
or fashion.
No, it wouldn't be through me. It really should be through staff.
Yeah, I would say contact staff, and if it's a question
And-
that we don't know,
Okay.
we can always ask them
Take
for the
care of it.
advice.
Okay.
Or we'll ask the prosecutor's office, they're also a
Yes.
resource that we use, so.
Is it
Thank you very much.
Thank you. all.
Possible to get this electronic?
Of course.
Yeah, I'd love to have it
I'm
electronic.
usually not a paper person. It gets lost inside of like 10
we have
minutes.
it.
So, but if it's on my computer, I'm like, oh, I have a question. I
There
can go right
forever.
back. It's
Yeah.
there. So that's like, I was going to ask you the same thing about
See,
that.
and
It's-
I like the paper. I guess I'm old school enough.
Yeah. But we have both. We'll get you an e-copy.
Like one too. Yeah.
We will send it to you.
I'm gonna put that thing
You
through
guys.
ChatGPT immediately.
All right, well,
Summarize.
thanks.
that sometimes.
Appreciate you
It's like,
coming out.
like, I'm stumped for something. I'm like, I need a
Give
name.
our
and I'm
best
like,
to Peter.
I will.
I'm gonna try it. I've never done
I
it.
miss him.
Tell him.
So, okay, the only other thing we have on the agenda is election of officers, and what's your pleasure? I'm kind of open to suggestion on this, how you want to handle this, because there's a couple, well, I'm not gonna, you guys have the script. You guys decide how you want to do this. And boy, did it get quiet.
And the script is a guideline, you don't have to follow the script however you want.
I
up to you.
understand that some committees, zoning, just do a vote on maintaining the current.
Yeah,
Right.
if that's what you choose to do, that's
If
what you can, that's what you
wanna
can do.
And if you don't, then we can follow the script, whatever you want to do is fine with me. So I am definitely flexible, so.
Well, I propose a motion that we nominate Mr. Harmon to continue as our chairman. And in recognition of the terrific service he's provided, and at least in my observation. And I'd love to hear a second.
Right, second.
Okay,
That's that
any
one.
other nominations? Any discussion? And I can go out there if you want to talk about me, because if I get past that door, I may get in that little white car and go. But, okay, then.
I was assuming you would accept it.
Yes,
All right.
yes. Thanks for asking, though. Usually people just make me do these things.
Well, the thing is that you would do exactly what you did, even if you didn't want it.
Yeah, I know.
You know?
I figured if I didn't show up tonight, yeah, anyway, it's another story for another day. Okay, all in favor of me continue as chairman for the next year, signify by saying aye.
Aye.
Any opposed? Okay, motion carries. I'm going to nominate Teresa Yu as vice chair, who she is the current vice chair. And I will entertain a second. Second, okay. Any discussion? Anybody? You guys are so easy because you don't know any of us.
New.
Yeah.
All right, I'm going to say it right now. I got 3, so I'd like to go through the process. So, yeah.
All right, all in favor signify by saying aye.
Aye.
Any opposed? Thank you. I should let you know, if we, are we gonna, do you think we're gonna have a meeting? Oh, here.
Yeah, do we
Um,
know if we're
We
having?
did not receive any applications
Hold
for
on,
the next
hold
month.
that thought, because I'm gonna ask off the record.
Yep.
Um,
Oh, we're on the record.
Okay,
so-
if I don't hear
Yeah.
any, is there any other business that we need to conduct? Hearing none, I'll entertain a motion to adjourn.
Make a motion to adjourn.
Okay, and a second, I'll second. All in favor?
Aye.
Any opposed? No, we are adjourned at 8:42. All right.